Good morning, everyone. Welcome to the second day of our spring oral argument session here in Philadelphia. As you may know, because I say it all the time, our Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and the Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. We celebrated our court's historic 300th anniversary here in Philadelphia in 2022. We are privileged to sit in three historic courtrooms: Harrisburg, Pittsburgh, and Philadelphia. Here in City Hall, the facade of the bench is constructed of Mexican onyx, with each of the 7 panels divided by bronze statuary representing the Greek figures of law, justice, and jurisprudence. To the right of the bench is an Italian marble bust of John Bannister Gibson, Chief Justice of Pennsylvania from 1827 to 1851. To the left of the bench is a bronze bust of George Sharswood, Chief Justice of Pennsylvania from 1879 to 1882. Chief Justice Sharswood was a well-respected member of the Philadelphia Bar. Directly behind the bench is a mural completed in 2002 by 2 local artists, Michael Webb and Max Mason. The view is of Independence Hall's southern facade, with the historic Pennsylvania Supreme Court courtroom to the left. The interior of both our courtroom and the Justices' Conference Room were designed by George Herzog, an American interior designer and decorative painter. While you are here, I hope that you will take a moment to observe the majesty of our courtroom and its tributes to our system of justice. I'd like to introduce a group of students who are here with us today. They are students from my alma mater, Lincoln High School in Elwood City. The students are part of the AP U.S. Government and Politics class and also the American Government class, and they are here with their teacher, Mr. David Gabus. I believe this is the 12th year that Mr. Gabus has brought his students to Philadelphia for an educational tour, and they always spend one day observing our oral arguments. So I'd like to welcome them, and students, if you would stand, we'll recognize you. Welcome to Philadelphia. Thank you. I hope that you learned something from our arguments, and that is certainly a lot of pressure on the attorneys to make sure they encourage these students to go into law. Before we hear the first case, let me just mention a couple things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. After that, you may begin by stating your name and the party you represent and introducing your co-counsel to the court. The justices are familiar with all of your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is always welcome to rely on their briefs for particular issues. I also remind you we do not permit rebuttal. In cases where there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when we are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues that we want to explore further. While there's no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I ask that you conclude your argument. Mr. Minner, please call the first case.
In re the 30th County Investigating Grand Jury, representing the petitioner, Ms. Sarah Jones, representing the Commonwealth, Mr. David Markowski, representing the Attorney General, Mr. Ronald Eisenhower.
This case involves objections by petitioner, an employee of a police department, to the public release of an investigative grand jury report in which the employee's official conduct is discussed, along with the conduct of other employees of that department following the death of an individual while in custody. Petitioner testified to the investigating grand jury that he was permitted to offer a written rebuttal to the grand jury's findings. The supervising judge redacted petitioner's name from both the grand jury report and his rebuttal. Petitioner raises 3 issues. Number 1, whether the report met the statutory definition of an investigating grand jury report under the Investigative Grand Jury Act. 2, whether the findings in the report were supported by a preponderance of the evidence. And 3, whether the publication of the report violated petitioner's right to reputation secured by Article 1, Section 1 of the Pennsylvania Constitution. Further, we exercised extraordinary jurisdiction over the following question: what type or degree of criticism of a named but not indicted individual in a grand jury report warrants notice and an opportunity to be heard under the Investigative Grand Jury Act? And did the supervising judge's discretionary decision to provide notice and an opportunity to be heard to some, but not all, named yet unindicted individuals in the grand jury's report comport with principles of due process and the fundamental right to reputation protected by Article 1, Section 1 of the Pennsylvania Constitution? In entertaining argument today, I ask counsel and, of course, the court to be mindful that the grand jury report at issue in this matter remains sealed, and that although redacted briefs addressing the legal issues presented were publicly released, petitioner's identity remains confidential, as do the details of the other individuals and entities involved. Good morning.
May it please the Court, Sarah Jones on behalf of petitioner, and good morning. I'd like to also introduce my co-counsel, Mr. Gregory J. Pagano. May I, Justice? I'd like to first start with the Court's question, and that question is a compounded question that involves 2 parts. The 2 parts, and I have short answers to both parts. The first part, the answer to the question, is any criticism. Any criticism of any individual in the grand jury report should have an opportunity for that person to be heard and receive notice that they are in the report and give them a chance to respond. I'd like to cite to Justice Dougherty's concurring opinion in Re 40th. He states, and if I may look at the opinion, he states in his 6th recommendation that once the court approves publication of the report, any criticized individual should be given the opportunity to file a public response. As the rule currently states, if the supervising judge finds that the report is critical of an individual not indicted for a criminal offense, the supervising judge may, in his sole discretion, allow the named individual to submit a response to the allegations contained in the report. I'm asking the Court to find that the grand jury report statute is unconstitutional today and to seal this grand jury report. The reason for that is because the statute, as it stands, offers only discretion as to those who will receive due process.
Do you think, counsel, that I thank you for the clarity of your argument, and you've gotten to the nub of at least one of the issues here. Do you think that if we were to reject your facial challenge, that we would be outside our authority by affording everybody criticized the various due process protections, or would that be rewriting the statute?
I think it would be rewriting the statute, Justice. As the statute stands, and I understand that this Court does not have the ability to rewrite the statute, the 2 words, sole discretion, gives the trial court judge only the ability to give. They could give everyone the notice and opportunity to respond. But with it being in their sole discretion, due process can never be discretionary. It's a fundamental right that
We
we,
already started down the road. I guess I'm thinking about the cases we had already. Have we already started down the road of rewriting the statute? And if we have, by what we did in those cases, and if we have, is there any harm, so to speak, in continuing to, quote, rewrite it by affording these protections to everybody criticized, such as in the way that the OAG has proposed in this case?
well, I guess I would disagree that the statute has been rewritten. In Ray 40th, the court comes to the conclusion that the preponderance of the evidence is probably not an adequate safeguard. It also comes to the conclusion that the right of a response is also not an adequate safeguard to the due process rules. And thus the court found that redaction was the only way to preserve this fundamental right. With that being said, I don't believe that the statute was rewritten by this court. I believe that with this question being presented, I sit in a seat that the court has allowed me to sit in that otherwise I wouldn't be able to sit in, because these people that have been mentioned in that report that did not receive notice and there was no opportunity to be heard would be thrown essentially by the wayside. They don't know that their names are in this report. They never had this minimal due process that is afforded by the statute. Thus, there is no due process. Although due process is one that is a flexible right, it's not a discretionary right. It's a fundamental right. And the word sole discretion in the statute is what makes this statute unconstitutional.
Counsel, do you, over here, other side.
I apologize.
We look
It's
a lot
okay.
alike. He's really skilled.
You should see me on Friday nights. I guess I'm wondering, are you conceding, which lawyers always say no, are you conceding that if these individuals had received notice and if they had been given an opportunity to append a responsive letter or whatever it is, that would satisfy due process and remedy a violation of the reputational right?
To answer your question, going back to In Re 40th, the court has found, and no, I'm not going to. To answer it in short, I am a typical lawyer, so no. No, I don't believe so, because, and one reason I don't believe so is because this issue is going to come up over and over again, and there's no way of stopping it as the statute currently stands. The sole discretion is going to continually be an issue. And but for this court asking this question, it's an issue that never gets to be presented. There is no attorney for these people that are named in the report and criticized. And I'd like to cite back to the AG's brief, the Attorney General's brief, because they mentioned 9 people in the report, as it stands, whose names are in there that have been criticized, and they have had no notice and no opportunity to respond. They never knew that this report was created. They never had a chance to confer with counsel.
Counsel?
Yes.
In the middle. Almost, not quite in the middle. Your argument is that citizens in Pennsylvania are protected against criticism.
Yes.
Okay. What's your predicate for that notion?
That we have a fundamental right to reputation.
And are you suggesting that in this case where we're dealing with public officials or public officers, they have that same right not to be criticized for the performance of their duties?
Specifically right now, I'm talking about those that are not necessarily public officials. I'm sitting in a different seat than I am for petitioner right now in response to the court's questions. And if I may briefly look at the AG, Attorney General's office brief, they mention all different classes of people, those that aren't public officials, those that are not in the police department. These people have been criticized in this report. These people have a right.
They're all performing public functions in the context of this episode, correct?
I would disagree. No. There are people that are not serving public functions and some of the lowest public functions. A public official can't be compared to someone that just works within the public sphere. And I would disagree that all of them even work in the public sphere that are criticized in the report.
Let me probe a little bit more this notion that the right to reputation protects individuals from criticism. Doesn't the right to reputation in Pennsylvania track defamation law in Pennsylvania?
It does. Libel, slander, defamatory meaning, out for ridicule in the world. That's traditionally what the case law has said. I believe that many, at least 10 people mentioned in the report as it stands, meet that definition. There's over 50 people named in this report.
But unlike, if I can follow up on that, unlike the 40th case, which involved people who were not public employees, why shouldn't we view this with a different lens? Why shouldn't we draw a bright line for people who are paid for by the taxpayers, people like us, or people like your opposing counsel? We're paid by the taxpayers, and why shouldn't we be susceptible to criticism?
It's not a matter.
At least at the Sullivan versus New York Times level. Can you address that?
I don't think it's as much of an issue as being susceptible to it as it's giving a right to respond to it. We're all susceptible.
That's different than I think what your original read on this was, and it's certainly a different answer to a question that I haven't asked. I mean, I'm really probing this notion as to whether or not individuals who are public officials are paid by taxpayers, are they protected from criticism in the performance of their duties? I mean, does the reputation clause of our Constitution extend that far?
I think they are protected. I would argue that they are protected. Although in Ray 40th dealt with something very different, and a public official is differentiated in that case, I would still say that there is a right for them to reputation as a public official. Just because you're a public official doesn't mean that due process is automatically out the window and doesn't apply, and I don't believe that that's what the case law essentially says. Is it a lesser, is it possibly a lesser burden? Yes, I would agree, but I don't.
Isn't it hard to do what you're suggesting? I mean, it's certainly being critical of an employee to say she's late for work every single day. I mean, is that subject to defamation laws in Pennsylvania? Is that subject to the procedural mechanisms that you're suggesting needs to be in place? I mean, that's a criticism. That's why I'm probing this notion of criticism of a public employee.
And I think, Justice, that looking at the report as a whole also needs to be taken into consideration with that.
You're asking us to declare this statute facially unconstitutional. And so, I mean, that's why I'm trying to get to the outer limits of what we're talking about here. And along those lines, I mean, am I correct in assuming that we would have to apply strict scrutiny
Yes.
to this, the Grand Jury Act.
Yes.
In that regard, what is a less intrusive means of accomplishing the intent of the legislature to allow a forum for the investigation of public corruption and in a way that gives citizens a right to participate in that investigation?
Well, a less intrusive means, Justice, would be allowing, would be a statute without sole discretion in it, in my opinion. It's the discretionary part that's problematic.
Well, let me ask you this question. In the role of this court, our rulemaking function, do we have the authority, as opposed to what you suggest is rewriting the Grand Jury Act, do we have the authority to implement rules for the conduct of the grand jury? Without touching the act. I mean, we create court rules on a daily basis, I might suggest, for better or for worse.
Of course.
So,
Of course, but I think that that wouldn't change the fact that the trial judge still has discretion in who and who is not receiving notice. In this case, the trial judge decided that certain people weren't entitled to notice because there wasn't criticism. I'm assuming that was done between the district attorney's office and the trial judge. But that goes back to a judge deciding what is and what is not criticism, and then
doesn't that get back to my original question? I mean, is all criticism actually protected by the reputational right under Article 1, Section 1? I mean,
no, not all.
She's late every day.
Not all, Justice. But in this report, there is criticism that meets the definition of criticism.
So says you. So says the AG. How do we review the grand jury judge's exercise of discretion in that context? Isn't that what it's about?
Yes, it is what it's about. It's about giving those that are entitled to due process and giving it to them. I think that it goes back to the fact that, Justice, that had this court not asked this question, and once another grand jury, if that happens, report comes before this court, there are individuals that will not have the opportunity to be heard at this podium as the statute stands right now. It cannot be discretionary.
But counsel, I think, I guess piggybacking off of Justice Donahue's question, I think you have to acknowledge, as Justice Weck said, that criticism of public officials, pure criticism, I think Justice Donahue said she's always late or something like that, may not rise to the level of a constitutional harm that triggers due process. But there is precedent in Pennsylvania dealing with stigmatization of public officials, where you get a name-clearing hearing under Loudermill. So is that the trigger? It's not just mere criticism, it's criticism that stigmatizes the individual with some kind of reputational harm that rises in a Loudermill context to triggering a due process right.
Possibly. I think that goes into then some type of pre-deprivation hearing if we're going along those lines, Justice, which that had been flushed out.
Well, that's why I keep going back to your idea of this case would be okay. And again, I'm not sure you're saying this, but that this would be okay if they just had notice and an opportunity to submit a responsive report. If it's true stigmatization in the Loudermill context, they would need more, wouldn't they, to remedy due process?
Yes.
So are you saying that all we need to do is order notice and an opportunity to attach a report, or are you asking for more?
what I'm asking for is there not to be discretion in that decision.
Well, that's what I'm saying. You're focusing on that discretion. I'm not sure I understand. So if we demand, if we say that the discretion of the trial court judge is wrong, and we say, no, in every case, anybody named has to be given notice and an opportunity to file a responsive report, you think that remedies the constitutional violation?
I think that that's a start to remedying the constitutional violation, but I think that that would entail rewriting the statute as it stands.
Not necessarily. I mean, Justice Donahue brought this up a few minutes ago. We do promulgate rules. Isn't it possible that with the existing statute, without us declaring it unconstitutional, we can promulgate rules that would provide the remedy you're seeking?
Yes.
Okay.
Okay.
Let me ask you this, counsel. Suppose instead of this grand jury report, the Philadelphia City Council had issued this document. Obviously, they would have come to it through a different means. They wouldn't have had the various powers the grand jury has. But nonetheless, they came out with a very fulsome document like this and went into all this criticism. What's your remedy there? There is none, right? That's criticism of public employees.
It is, and it's in a different forum, Justice. I believe In re 40th talks about the fact, or excuse me, it's actually the 2017 task force that talks about the fact that are grand jury reports really necessary when we do have other means to, we do have other legislative and administrative means to explore these issues, which I think is what you're getting at. This is a report that's issued by a governmental agency, the district attorney's office, and in some instances the AG's office. It holds a certain weight to it.
Well, that's my question. Is it a city council is a governmental agency? It's not without its weight, presumably. So is there something more solemn about the grand jury report? That the stigmatic effect is different in some way?
Well, yes, I believe that it essentially accuses people of crimes, crimes that are uncharged and not indicted.
The city council could do that. The city council could do that, and I'm just wondering what presumably there is some distinction, but what is it?
Would the difference be that the district attorney's office could arrest an individual, but city council could not?
Yes, Justice Doherty.
So really what's here is liberty interest.
Yes, fundamental due right and liberty.
Except that the DA's office is not arresting any of these people.
Yeah, what liberty interest? I mean, they haven't been arrested. That's your complaint.
It's the reputational interest, not the liberty interest, isn't it?
Had they been arrested and tried, they would have had a full hearing. I mean, this issue arises when individuals are not arrested.
They're not arrested, but they're accused still. As the report stands right now, they're accused of various crimes within the report. And I understand your point is that the city council could do that. They could make those same types of allegations.
Yeah, I mean, I just because following up on the questions about reputation, I understand you're asserting a reputational harm by a governmental agency, and I just wonder if we are thinking in disparate terms about different ways in which that harm could happen.
Well, I have not read a report issued by a city council justice. I've only read grand jury reports issued by government agencies that allege some type of crimes. But I would say that those people mentioned in those reports have also a right to due process and reputation as well. I'm not well versed on those reports, and I won't pretend that I am justice, but we all have this fundamental right, and I think that's what this comes down to.
I agree entirely, and I feel very strongly about the Article I rights in general, right to reputation being one of them. But I'm just struggling with the context of this case, all grand jury reports. I mean, we're either talking about public corruption or we're talking about findings and recommendations that go to, ameliorate public concerns. In general, we're going to be looking at individuals who are public officials or public employees who are performing public tasks. And I just think it adds a different dimension to this notion of what's allowable criticism, to use your phrase. I mean, frankly, it's a much better argument in the cases involving the Catholic priests. I mean, they were truly private individuals, but that a whole different issue there. But in this case, this is a pure case of public corruption.
And I think that, Justice, we've agreed to disagree on the fact that I don't believe that everyone in this case is a public official. If I work at the district attorney's office as a paralegal, and I'm accused of doing something that affects my reputation, does that automatically bring me up to the standard of public official?
The statute speaks not only of public official, but also public employee. So yes, you're paid by the taxpayers, you're a public employee, yes.
Well, I think that there's different types or degrees of criticism then that would be allowed. Do I think that being late to work? No, I don't think that fits within that purview.
It would not be an abuse of discretion to not give that person an opportunity to respond.
And I would agree with you on that, Justice.
But that's the discretion. That circles back to the discretion. So
It circles back to the discretion.
You want the discretion. Why could a common pleas judge not exercise the discretion then? And it's reviewable in the ordinary course, and even presumably via King's Bench or on some proper interlocutory basis. Yeah,
I mean, in this case, honestly, I'm not sure what we're supposed to do at the end of the day with this. But, I mean, ultimately, the AG may think that there are individuals who were improperly criticized without an opportunity to respond. Somebody else may hold that view. But ultimately, it would be our responsibility, I believe, to decide whether or not it was an abuse of discretion in those circumstances. Is that right?
I would believe so, too.
Counselor, are you aware of In re Chalk? That is a 1971 Supreme Court case.
Not off the top of my head, Justice.
In essence, it said, the essence of that case is that the particular public entity, because it is that particular public entity, doesn't lose constitutional rights or forfeit constitutional rights because it is a public entity.
And I would agree with that.
And there's no case law that has overturned this court's precedent from 1971 saying that that particular department suffers any less rights because they are employed by that particular department.
And I would agree with that as well.
You do agree that I assume you agree with opposing counsel that the law of defamation is the driver in analysis of reputation cases?
Yes.
One more time, and you probably answered this, and I wasn't listening closely enough. Strict scrutiny.
Yes.
What is a less intrusive means of effectuating the intent of the legislature in enacting the Grand Jury Act?
A less intrusive means would essentially be for anyone that had criticism to receive due process. I hope I'm answering your question. I'm just not sure if that's possible with how the statute is currently written.
Okay.
Because your position on discretion, right?
Yes.
Okay. Is there any means by which you think due process guarantees and guaranteed rights can be protected in the grand jury process, less than striking it or short of striking the actual act itself?
To answer that, it would be that anyone criticized receives notice, which in turn would give them due process.
I'm going back to the discretion argument, and I'm going back to
Yes.
the abuse of discretion argument. You said that it's got to be stricken because of the discretion. You're giving the trial judge discretion and sole discretion. But we deal with that every single day, don't we? I mean,
Yes.
every single trial judge is given discretion on evidentiary matters, on the application of the rules of criminal procedure, and the standard by which the appellate courts take a look at that is an abuse of discretion. So if we're giving a grand jury judge discretion under these circumstances, are there any means that you think that are preventable from striking this particular act?
I don't think so, Justice, because at the end of the day, it goes back to my argument that as I sit here at this podium today, that person that did not receive due process.
Let's put that aside. Let's say everybody gets notice and opportunity to be heard. My concern is that a grand jury, an investigative grand jury, is a one-sided proceeding, right?
Yes.
You have an opportunity to respond through your counsel. You can send a letter on and say, hey, listen, I deny A, B, C, and D. It's appended to the report. But that doesn't really satisfy due process concerns, does it?
No, and In re 40th goes through that exhaustively, that what isn't currently in place does not preserve due process. The right to notice, you're not even guaranteed, the right to testify.
Let me back off a little bit then, because I'm trying to tease something out Justice Bratson was talking about and Justice Donahue. The purpose of this investigative grand jury was to determine the cause of death for an individual in police custody, correct?
Correct. And to apportion blame.
And to apportion blame. And they couldn't apportion blame. They couldn't bring charges against anybody. And then the investigative grand jury morphed into something else.
Correct. I would agree.
The reasons why we can't do this is because we believe there was some kind of cover-up going on here.
Absolutely.
And that's why all of these other individuals who were unindicted but criticized heavily were dragged into this particular report as a basis to kind of make recommendations on how internal police investigations should occur. In other words, the DA made certain recommendations that the DA should be involved in police investigations and the DA should have somebody in a room, et cetera, et cetera, et cetera. Correct?
Correct.
So my question is, does this really fall into the category of a report within the Grand Jury Act?
No, I don't believe it does. I think the report, and I won't go through.
Theoretically, if the purpose of the investigative grand jury was to determine what caused this individual's death and they couldn't conclude it, it should have been end of story, period. We can't conclude it without going into the reasons why.
I would agree.
What else do you have for us?
I have a lot for you. If the court would like, I have other arguments to all three parts. If the court would like me to continue with those arguments.
Counsel, I have one more question along the same lines that we've been talking about. The issue that you raised surrounds the abuse of discretion standard and the fact that grand jury judges have the right to exercise their discretion. If we clarified the law, I'm not sure how unclear it is, although I'm not sure it's really been talked about a whole lot, but if we clarify the law that any criticism of an individual has to be measured in terms of the law of defamation in the Commonwealth of Pennsylvania, and that's to drive the exercise of the grand jury judge's discretion, does that fix the problem? Because then, of course, if the grand jury judge doesn't apply defamation law to analyze the statements about the individual, that's an abuse of discretion, because
Yes.
it would be an error of law.
Yes.
Does that fix the problem?
I believe it does.
Now you've confused me.
Yeah.
Sorry. I believe if the court...
You seem to be focused on this idea of just getting notice. And I asked you this directly, and you said no. So I'll ask you directly again. If we say that the remedy for the reputational violation occasioned by being named, and I won't use criticized, because I think I think under Loudermill and the other cases dealing with public officials and name-clearing hearings, it's more than criticism. But you're saying that the remedy, that all you need is notice after the grand jury is done, that your name appears in a document, that the way in which your name is referenced triggers the reputational protection, and then all you have to do is be given an opportunity to append a responsive report. And you're saying that remedies the constitutional violation.
Well, what I'm saying is that if all criticized are given that opportunity of notice and to respond, then I think that let's face it, there's minimal due process afforded in this.
Well, no. Don't talk about minimal due process. It either satisfies due process or it doesn't satisfy due process. And you're saying that all you need to satisfy due process to reclaim your reputational right is notice and appending a response. You're saying that remedies. You don't get to face your accuser, you don't get to cross-examine witnesses, you don't get to do anything. All you have to do is get notice from the judge so you can draft a report and attach it, and you're saying we're done. That's all we have to do.
No, I'm not saying that. I'm saying it in response to the court's specific question.
It would fix that problem.
It would fix that problem. So, and that's what I apologize, that's specifically what I was referring to. Not as a whole, but it would fix that part B of the court's question.
Okay, so your point is if you give that to some people, you have to give it to all, but that doesn't mean that remedies all.
Correct.
Okay, now I understand.
In follow-up to Justice Brobson's question, would your view of notice and opportunity to respond be more in line with the dissenting opinion of Chief Justice Saylor in the 40th grand jury case?
I would say mine would be more in line with Justice Dougherty, his recommendations, Justice Dougherty in 1 through, I believe, 8 recommendations.
I'm just a little bit surprised at that because I think Chief Justice Saylor at the time advocated that people in the position as your clients should not be given just notice to respond, but actually the opportunity to advocate that the grand jury's findings are not supported by the preponderance of the evidence, and that he strongly urged that due process could not be met without affording those people those particular rights to actually be present before the grand jury and advocate their position.
And I agree with that as well. And I believe Justice Dougherty talks about the fact that these people should be afforded the right to testify and also be before the court and have an opportunity to challenge these remarks. So yes, I would agree with both opinions.
So in short, you really like that Dougherty opinion?
It's my favorite.
Counsel, we are here to listen to whatever argument you want to present, but you can also rely on your brief for, remaining angles and arguments if you'd like.
Justice, I would say the remainder of my argument would largely rely on the brief. Again, I don't want to take the court through In Re 40th again and over again. The court is well versed on In Re 40th. The court has made findings that they do not believe that preponderance of the evidence is, an adequate safeguard to due process. The one important part that I would like to touch on is whether or not this report fits in the statutory definition of a grand jury report. And as the court knows, the statutory definition, the report must relate to organized crime, public corruption, or propose recommendations for legislative, executive, or administrative action in public interest. I would argue to the court this report does not fit any of those. I won't go through the facts of the report. However, it's clear that the legislative recommendations made in this report are an afterthought. The report,
Why? Because it was shorter than the rest of the report?
Yes, there's 107 pages in this report. 100 pages.
in 2 paragraphs, and I believe that, didn't the district attorney's office say their recommendations are impractical but should be tried?
Yes, that is what's stated.
I need the DA to explain that to us.
That is what's stated in the report, and the purpose, sorry, if you're in the process of asking a question, I don't want to cut you off.
You can finish your answer.
The purpose of the report is to apportion blame. That's the purpose. That's why this district attorney's office brought about this report, a report that's already been, or something that's already gone through a process previous to this court's process today. I can go on and on about issues within the contents of the report, going back to who the district attorney's office decided to name and who they decided not to name in this report.
Pardon me. The district attorney decided? I thought the grand jury decided.
Well,
Who would be named in the report?
if the grand jury did not hear,
And the judge allowed individuals to be named, correct?
correct, but there's some that are not named because these people have not been called. There's one important person that was very much involved in the original investigation of this report, and he was not called.
Can I ask you on your point you made a moment ago, counsel? You asserted that the report here does not fit within the statutory definitions. Public corruption is defined by the legislature as, quote, the unlawful activity under color of or in connection with any public office or employment of any public official or public employee, et cetera, et cetera. So I think as you characterized the report, it alleges in part some sort of cover-up.
Yes.
And it alleges a lot of other things, and we've all read the whole report. Just going to the definition, the categorization, why, granted you disagree with it, you find it problematic under the right of reputation, et cetera, but just on the definition, why is it definitionally not within the category of public corruption as defined by the legislature?
And I would argue that those in this report were required to investigate this incident. I don't think that the report makes out that numerous people engaged in unlawful activity under the color of law, especially petitioner, who in his response clearly, and now I'm switching seats to arguing only on behalf of petitioner. I think that he clearly lays out that what he was required to do in his job, and he did it, and that's why I don't think it meets the definition.
I understand you have a difference of opinion. I respect there's a difference of opinion here, but to argue, because now we're in a separate argument, obviously, to argue that the report the grand jury issued does not allege public corruption, I think is categorically, I think it's a difficult argument to maintain, but go right ahead.
I think it's a difficult argument to maintain, but I think it can be maintained, and I'm going to cite back to our brief in that the main reason we don't believe that it's related to public corruption is because of the fact that these officers were required, they were required to do this investigation, and that's why it does not fit.
But I'm required, and we're all required as judges to do what we do. But if we engage in some aspect of that work unlawfully, then we would be categorically here too, right? I mean, in other words, I grant you that your client and these others were involved in doing their jobs, but the allegations of the grand jury would seem to allege matters within this statutory category. No?
I would disagree, Justice.
Counsel, unlawful activity, did this result in any indictments?
No.
And unlawful activity, public corruption, is a crime for which the DA could charge.
Yes.
And after their second investigation, with regard to the same subject matter, they still did not find criminal activity.
Yes, for the second time.
Okay. So, in essence, where is the public corruption? So the report must have been just for recommendations only.
Yes.
And the recommendations, as put forth by the Commonwealth, was that their recommendations are impractical but should be tried.
Correct.
Well, the allegations made by the grand jury include that the activities of certain persons, certain public employees, made it impossible by virtue of delay and other activities to pinpoint the blame, right? Because it could have been officials of your client's agency. Also, there could have been defalcations by the medical facility, defalcations by the correctional facility, and so that the lapse of time and other circumstances made it impossible to bring charges. Isn't that part of the allegation by the grand jury in this report?
It is part of the allegation. I think the allegation is that numerous agencies throughout Philadelphia conspired together, and that conspiracy gave a certain result, which is
A RICO matter.
essentially, yes, a RICO matter.
Yeah, no, I understand there's a fervent disagreement here. I understand that. My question went to your categorical assertion that this doesn't fall within the statute's definition.
And my answer to that was that I don't believe it falls within it because those involved had a duty to investigate this. And I know that you said that, well, the court could stand in that same seat, but it's not public corruption, going back to what Justice Doherty said, because essentially no one's even been charged for any of these things. There's tons of allegations within this report from, to go back, from people low to high.
I'm missing your point here, and maybe you just need to explain it to me one more time. I don't understand why this doesn't fall within public corruption. You've answered it a couple times, but I'm still not convinced. Do you want to try again?
Yes.
Thank
May
you.
I have a brief second?
Sure.
Thank you.
And let me supplement that by
By
asking you.
disagreeing with me.
Let me supplement that by asking, what is the definition of unlawful activity that's provided by the Grand Jury Act?
Unlawful, oh, gosh.
There is none.
I was going to say, I don't think I've seen that one yet, Justice.
No one has. Just public corruption, which means unlawful activity, which means there has to be some act that's indictable.
Does it, though? And I guess that's what I'm probing. Even if it's not indictable or someone isn't charged for some reason, such as a statute of limitations or the like, that doesn't necessarily mean we're not talking about public corruption, does it?
Well, I guess your point, Justice, is that even if someone was not charged, that there still can be.
The tenor of the entire grand jury investigative report could be about public corruption, couldn't it?
Well,
Allegations.
yeah.
Allegations without a conviction equals slandering of a reputation. That's the issue before this court.
Well, now it cycles back to your initial argument about the right to reputation. You see how it's circular now? Because if in fact nothing is unlawful, if the argument amounts to charge me or never name me, then that's where we are on your right to reputation facial challenge, right? But otherwise, we're in a gray area. You follow what I'm saying?
yes, I do follow what you're saying.
Counsel, could you just refresh my recollection? Were any of the Catholic priests involved in the 40th investigating grand jury charged? Any of them who were mentioned?
Not to my knowledge.
Okay, and does that mean that there was nothing to see there and the grand jury couldn't report on it?
Well, I think that the ultimate, in Ray 40th, there was legislative recommendations in that.
And some would suggest that they were impossible to carry out, because here we are how many years later, and we still don't have those legislative fixes that were recommended. But it was perfectly within the purview of the 40th Investigating Grand Jury to recommend that kind of legislative action. I mean, this notion that what this grand jury recommended may not be practicable. I mean,
Well,
I don't know how that obviates the fact that there's still recommendations.
I don't think that's the only issue with their recommendations. I think the fact that their recommendations were an afterthought and it's a very small portion of this report goes to the fact that if now we're talking about the legislative recommendations, I think it was clearly an afterthought. In the first few pages, the purpose of the grand jury is to apportion blame and give answers. That's what the district attorney's office wrote.
Isn't that essentially how the prologue to the 40th Investigating Grand Jury report started? Or maybe you never saw it because it was redacted. But, I mean, I don't think what happened here is unusual. I mean, and don't misunderstand my questioning. I think that the this Grand Jury Act is very problematic. But
I would agree.
This is the legislative policy expressed as to how to look at the issues that they have articulated, one of them being public corruption. So, I mean, we sort of have an obligation to try to save it from where I sit.
Understood.
You want to wrap up?
Yes.
Or have you?
Thank you for the opportunity to argue in front of the court today. In sum, I would still ask that the court find the Grand Jury Act unconstitutional. And again, I'd reiterate that based on the various reasons brought up today, I'd ask for a permanent sealing of the report.
Thank you, Ms.
Thank you.
All right, let's move on to the appellees.
Good morning, Madam Chief Justice. May it please the Court. My name is Dan Margolski. I'm Assistant District Attorney in Philadelphia, here on behalf of the Commonwealth. Your Honors, this appeal presents a paradigmatic case for when grand jury reports are absolutely necessary.
I'm going to ask you, sir, to raise your mic even. You're very tall. Yes. Thank you.
Thank you, Your Honor. So, Your Honor, this appeal presents a paradigmatic case for why grand jury reports are necessary, and that's for the following reasons. So, the grand jury had a multi-year investigation into allegations of criminal activity in office, or potentially criminal misconduct in office. That investigation was hamstrung, the grand jury concluded, and the grand jury, there's no other outlet for the grand jury or for anyone to make public or to hold accountable the reasons for why that investigation was hamstrung.
I think I don't want to jump in too soon, but that's a very interesting statement that you just made, that in the absence of the Grand Jury Act, the district attorney is impotent to say, we, the district attorney's office, conducted an investigation. We found all of these problems, but we can't bring charges. This was corruption. This was this. I mean, the district attorney couldn't stand on the dais at a press conference and make these allegations, couldn't issue a press release, couldn't. if we just didn't have, if we didn't have the grand jury, none of this would come to light.
Well,
That's your argument.
well, Your Honor, because I think that press release would not be able to be released because of the grand jury secrecy
I'm
obligations.
sorry, I didn't hear you.
I'm so sorry. Because of grand jury secrecy obligations, Your Honor.
No, I'm saying, let's just say there wasn't an investigative grand jury, because you didn't need an investigative grand jury. The district attorney's office has any number of resources available to them to investigate crimes and public corruption. They don't have to always do it with an investigative grand jury, correct?
Not always, Your Honor.
So you do your investigation, you don't use an investigative grand jury, and at the end of the day, you reach the same conclusions that an investigative grand jury would reach. You're saying that you couldn't issue a district attorney sealed report with a seal on it, not sealed and meaning not public, including the same recommendations, including naming the same names, that is impossible for your office to do?
That would not be possible without the information in order to acquire, so you need to first acquire that information. So Your Honor is correct that the district attorney's office has means of acquiring information. The grand jury has additional means that will compel testimony and compel the production of documents that were instrumental in this particular case in ascertaining what happened. So I don't think under the facts of this case, I mean, there certainly would be other investigations that the district attorney's office could do that wouldn't necessarily require the resources of the grand jury in order to obtain the facts.
It's all about the power of subpoena and the power of contempt. It's a grand jury. I mean, that's the answer, isn't it?
I think so, Your Honor, yes.
Well, isn't there an additional answer, though, and I believe we delved into this in the 40th grand jury case, that there's a gravity and a sense of importance and seriousness to a grand jury report that does not exist in just any report of any agency.
So that is recognized in In re 40th, Your Honor, that's correct. And I think actually that dovetails a little bit into what I want to talk about in terms of the answer to Your Honor's question 4 about the reputational rights and what the standard is that would attach someone's reputational rights. Because Your Honor is right, when In re 40th addresses the the nature of a grand jury's report as compared to other kinds of government speech, that was something that In re 40th thought was really important, or this court thought was important in In re 40th. So in Your Honor's question 4, the way I would think of it is, first we need to understand sort of what the right of reputation is. And I think it's not mere criticism. It's, we think of what is reputation. It's your character, your good name. It's what people think that they know about you before they know you, right? And so mere criticism, I think, as petitioner conceded about, being late to work, or there's some level of threshold of criticism that doesn't implicate or impugn someone's good name necessarily. And I think it was Your Honor, Mr. Justice Wecht, who raised the city council report hypothetical. And I think that's a really important other thing to understand, is that the right of reputation is not only a right as against the grand jury in a grand jury report, and it's not only against sex offender board in making recommendations about sexually violent predators. It's a right that exists as against all government action, and that's because this court has recognized that the right to reputation is on the same plane as the right to life, liberty, and protection of property.
Let me stop you there and ask you a question.
Of course, Your Honor.
Over here. It's been reported that there are certain district attorneys' offices who keep a do not call list. You heard that?
So,
in other words,
yes, Your Honor.
a list of officers that it's not going to call because the DA's office has made a unilateral decision that this particular officer, because of something in their background, have credibility problems. You've heard that, right?
So,
are you aware of that?
So I'm aware of that case.
So let me follow up on that. If you have a grand jury report that names 30 or 40 individuals who are alleged to have participated in a cover-up, wouldn't that impugn their reputation to such a degree that you're also talking about liberty interests or property rights, perhaps, in their ongoing employment? I mean, if you have a police officer's job is to investigate crimes, to make arrests, and to testify credibly in front of a grand jury or in front of a jury, right? If your reputation has been impugned because of your inclusion in a grand jury report and you are then put on a do not call list, doesn't that impact not just your reputational rights but your liberty interests?
So that do not call list question, I think, implicates other constitutional obligations, including the Brady obligations under the federal Constitution. So that becomes somewhat more complicated series of issues there.
I'm not talking about Brady interests. I'm talking about, in this particular case, these individuals are alleged through investigative grand jury to have participated in a cover-up which justifies your public corruption argument, does it not?
So, well, it's hard to get into the specific facts of this in an open session, Your Honor. I do think that so when a person's reputation is impugned by government conduct, that person has, needs to have some right of relief in some forum. And then the question needs to be, well, what does it mean to have your right of reputation impugned? So basically, I think of it as sort of a two-step.
What's the right of relief to somebody who is actually named in an investigative grand jury as participating in a police cover-up and placed on a do-not-call list? What's their right?
Well, so
what's the remedy, I should say?
So I'm not sure about the do-not-call list aspect of it, Your Honor, because, again, that implicates other constitutional rights or other constitutional obligations that the office has.
Well, you're talking about the constitutional obligations to criminal defendants who are subject to arrest or investigation by these particular officers that are on a do-not-call list. I'm talking about the reputational rights of the officers who are named in this report and then subsequently placed on a do-not-call list, because I don't want to speak for the rest of the court, but I can't imagine a situation where your office or any office is going to name an officer as engaging in a public corruption or cover-up and then being not placed on a do-not-call list.
So, so that question, Your Honor, doesn't. Again, I have to fall back on the idea that when we're talking about the do not call list, we're talking about do not call in a criminal case because of Brady obligations and obligations under other sorts of laws. My understanding of that.
But there's 30 or 40 police officers involved in this particular case. You're alleging a police cover-up. Don't you believe that would be a Brady obligation then?
I don't think that there's 30 or 40 officers, Your Honor, that the report is saying is engaged in a police cover-up. I think that's a misunderstanding of the.
I apologize. Is the Commonwealth alleging that there was public corruption in this case?
So as defined in the Grand Jury Act, yes. So
what was the unlawful activity? Because my understanding, by reading it, it could also be deemed clerical error and or mishap, miscommunication.
Right. So I think this is a misapprehension in the petitioner's brief. That's important to clarify here. The petitioner is describing it as the grand jury is finding a multi-agency, fantastical conspiracy that's not what the grand jury report found. It did find deficiencies across multiple different institutions. Not only the police department, but other institutions as well. Some of those deficiencies the grand jury found were in the nature, it could plausibly be mere negligence or slip-ups in certain instances, and then there are some that the grand jury did find were could not have been accidental.
But the concern that I have is that based upon this extensive report, there's only 2 paragraphs of recommendation. One being that we should people should document declinations of charges and or having third-party support. How does that go to the essence of this public corruption cover-up within multiple government agencies?
So I don't think that the claims about cover-up are applicable across multiple government agencies, Your Honor. And I think that's a misapprehension of the gravamen of the report.
The gravamen of the report is to, try to name officers in alleged activity that's not indictable.
So if I can go back to right, so that gets back to the initial question you asked, Your Honor, about how is this unlawful conduct? What's the unlawful conduct at issue here? And I think that when we talk about unlawful conduct, when we talk about public corruption, the definition of the statute is that it relates to
unlawful activity.
Conduct. Right. So the grand jury did find that that one or more individuals did use excessive force. Those individuals could not be identified. And so, and therefore, the grand jury would not be able to recommend charges against them. And the rest of the report relates to that conduct and the reasons why the grand jury believed it was unable to bring those charges or recommend those charges. So that, and excessive force, at a minimum, it's a Fourth Amendment violation, right? It would be unlawful conduct for police officers to use excessive force. So that I think alone, gets us there in terms of meeting the statutory elements. And then there's
Let's go back to that. How does that meet your definition?
So the grand jury does find that there's a high likelihood that, or I think almost certain is the phrase the grand jury uses, that there was excessive force used in a particular incident, but
they don't blame anyone because of the activity before their contact with police, the ramming of different cars, the injuries, the flight aspect of this. If I'm not mistaken, the grand jury said, we can't determine who caused it because of the activity, but it's excessive no matter what.
I don't think that's I don't fully understand what Your Honor is saying there.
What I'm trying to get is, when I read that report, there was a whole series of, after the alleged observation, there was a traffic rate, the individual hit many cars, was in several car accidents, got injured, ran away, whatever, all pre-police contact, physical contact. And the report came back saying, which is interesting, you called it a natural death, yet you allege unnatural causes, which, can you share with me how this court's to take that it's not an abuse of discretion to entitle a cover-up of a death of a person as the natural death of? Don't you find that somewhat sarcastic?
No, Your Honor. It says unnatural in the report.
Unnatural.
Unnatural. And that, I think, is the...
No, I believe it says natural, not unnatural.
I would rely on the record for that, Your Honor. I don't... If Your Honor...
Go ahead.
But I don't think that... It's certainly not intended to be sarcastic at all, I don't think. And it's hard to get into the answer to this question without delving deep into the record.
I agree with you.
And so the record, I think, is going to convince the court or not. But
let me ask you this. Let me have a follow-up. With the opaque recommendations, why are names even necessary? What are you trying to achieve if we're indicating that there's misconduct within the Philadelphia Police Department and we want to correct that? Or there's misconduct or collaboration between various entities within the city of Philadelphia. Why do you have to name names? Why don't you just discuss it as individual one did this, or describe the activity? What's the purpose? If your purpose is recommendation to the legislators, our city council, what is the purpose? It's different naming names when you're resulting in some criminal activity, not unlawful activity, that resulting in a conviction, a.k.a. an indicting grand jury. But we're not investigating. This is not investigating grand jury, such as maybe that was done with the Luzerne County scandal, juvenile scandal, where they issued a master to do an investigating report. Similar. But at the end result, for all potential defendants or individuals within the city and county of Philadelphia or elsewhere that may come under the purview of the DA's investigating grand jury, if the issue is recommendation, why do we name people? What's the purpose?
So,
other than to tarnish and stigmatize and impugn their reputation?
Well, so there are many people named in the report whose reputation is not, we're not criticizing, who are in fact, oh, sorry, Your Honor.
I apologize. I'd let you answer. I'm not concerned. Answer me why it's the office's policy to name individuals when no crime has occurred, so the sole source is to provide recommendation for better government.
So I think that and I think Your Honor is talking specifically about individuals who are criticized in the report, rather than folks whose conduct is.
It's a general question. I'm somewhat concerned. What is the purpose of saying Kevin Doherty did this, blah, 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 blah? Why not just say, as a result of individual, this activity occurred, my recommendation is don't do that, let's decline. I don't understand the nexus between naming an individual police officer and a recommendation to improve a sitting agency, that being the Philadelphia Police Department or any agency. There's a disconnect for me. Bring that together for me.
So first of all, many of those names of individual police officers were pseudonymized and made into, officer number 1, 2, 3, 4, et cetera, right? Certainly the officers who were involved in the initial incident, their names were not identified in the report as redacted and at the end of the process that Judge Scott oversaw. But your honest question as to why names are necessary at all, I think there's sort of two reasons for it, or really they're sort of connected. One of them is just that identifying specific individuals in some of these circumstances is necessary to understand what's actually being stated and to put meat on the bones of the report, to basically illustrate to make it clear that there is some that what it is that the grand jury is talking about here. So, for example, and that's I think with respect to and that was a big complaint that the petitioner had that even by pseudonymizing the petitioner's name, you still may be able to identify who that person is. There will be some individuals where that's the case. Now, I think, and there's also just readability issues. I mean, this report is so detailed and goes into as many of the circumstances as it does. If you get through like person 100, it becomes difficult to follow back. Well, who is person 100?
If you blacked out every name and let the report be read as it is, it's very telling. That's my concern. I don't see what the impetus is for the naming of names when it's for a recommendation.
Well, yes.
With regard to an alleged unlawful activity, since no public corruption, criminal activity was ever charged and no one was indicted after 2 investigating grand juries.
So the connection between the recommendation and the naming of names is in the Grand Jury Act itself. It's that the report under that prong is not just about giving recommendations, but giving recommendations on the basis of findings of fact, right? And that intertwined connection between the findings of fact and the recommendations is important in the Act, and it's important because, if the grand jury were to just give the recommendations that it had without communicating the factual basis for those recommendations, there's not as much force to it. It just comes out as it comes out as unreasoned, right? It comes out as not having the things that compelled the grand jury to give those recommendations, to not want to see this kind of thing happen in the future. You need to be able to communicate what those factual predicates were. So to the extent, and if I could shift gears a little bit to the question 4 about the right of reputation, because that I think implicates these individuals named in the report. Essentially, if we're trying to articulate what is the standard for when a person's right of reputation attaches.
Counsel, can I just interrupt you before you get to the right of reputation, which I'm very interested in? I want to step back for a second and understand. I sort of have a fundamental struggle with the idea of naming people in a report that aren't indicted. I want to understand procedurally how this works. If the grand jury returned an indictment of the named individuals in the report, those named individuals would have the presumption of innocence. They would be merely allegations of wrongdoing, correct?
Correct.
And so they would be presumed innocent.
Yes, correct.
Then, and the Commonwealth would have the burden to produce evidence. They would be able to call their witnesses, cross-examine witnesses, all those things, right?
Certainly, yes, Your Honor.
So when a grand jury chooses not to indict, under the Investigative Grand Jury Act, is it my understanding that a grand jury can not just merely now allege, because they're not allegations, they can find actual criminal conduct find it, not allege it, find it, but say we just can't indict due to A, B, and C. And so the investigative grand jury report becomes a finding of misconduct or a finding of unlawful activity, whereas an indictment is merely an allegation. The presumption of innocence does not attach, and there's no way to meaningfully respond. That's the scheme that we have in Pennsylvania.
Well, I don't agree with that last part of it, Your Honor.
Well, let me parse out one part. Did the grand jury allege unlawful activity by the named and unnamed people, or did it find unlawful activity by the named and unnamed people?
So I would say that it found that individuals who were not able to be identified, and whose names do not appear in the report that's going to be released, because you don't know who they are. That certain individual, that at least one of those individuals did in all likelihood violate a criminal act. I don't think that they say. I think they say almost certain is the word that they use. But there's no.
But it's not a mere allegation. There's no caveat to the report that says everyone named or unnamed in this report who's alleged of unlawful activity is presumed innocent, and these are merely allegations. There's nothing like that.
There are no qualifications like that, Your Honor,
right.
And that's consistent with, I think, also when we're talking about the underlying incident itself, right?
I'm trying to stay away from any talking about. I'm just trying to conceptually understand the statute and where the right to reputation attaches. What are the due process? To the extent the right of reputation attaches, and there has been more than criticism, but stigmatization, which is what you talk about in terms of Loudermill and a lot of the other cases dealing with reputational harm. What due process is someone entitled to? And if you get stigmatized in a criminal indictment, you are entitled to your day in court. You are entitled to a presumption of innocence. You are entitled to putting the district attorney to their proof. And you're entitled to bring your own witnesses and cross-examine. But if it happens in an investigatory grand jury report, that doesn't happen.
Well, certainly everyone who was given, who is alleged to have done anything that even approaches criminal conduct must and were given notice of the existence of the report.
No, I understand, but they aren't entitled to. The only one that presents evidence to the grand jury is the district attorney.
Well, I mean, yes.
The district attorney is the only one that calls witnesses.
Right. That's correct, Your Honor.
You cannot, if you are the subject of the grand jury, potentially, you may not even know about it, but you don't get to cross-examine those witnesses, for example.
That's correct.
Right. Your lawyer really can't do anything.
Your lawyer can sit in the room, but does not participate.
Right. So the protections afforded you to reputational harm are higher if you get indicted.
Well, and the resulting harm that you potentially face would be much higher as well, right? I mean, being indicted criminally and facing a criminal trial, you're facing the possibility of additional sanctions that make that additional process.
So which would you prefer? Which would you personally prefer? Would you prefer an allegation and a presumption of innocence, or an actual finding with no remedy?
I guess it's hard to say that in the abstract, Your Honor. I think it depends on what the situation.
Maybe we should leave it to the people whose reputations are being harmed to decide what they prefer.
Well, in this instance, Your Honor, I mean, and this is why it gets hard to talk about this except in the context of the specific facts that are at issue.
I don't think it is. Maybe just make up the worst facts. Make up a fact that you're investigating, the most heinous crime that you possibly can imagine, and you actually identify the perpetrator, but for some reason the investigating grand jury either can't recommend a charge or won't recommend a charge, but the investigating grand jury issues a scathing report, not just alleging that this person did the crime, but finding that the person did the crime. And the only reason we can't bring the charges is the person absconded or something like that. I mean, so take that.
Yeah. So that's similar to the situation that you have in 40th, right? And the court's remedy in that case was that the underlying facts could be revealed to the public, but the names could not. And that's a perfectly, I mean, that's the remedy there. You're given notice, an opportunity to respond, not only an opportunity to respond in writing to the report, but an opportunity to apply for relief, right? And apply for relief to the supervising judge.
Yeah, I'm wondering whether that's enough. I'm wondering whether simply given notice after the grand jury has done its work, meaning you don't get an opportunity to present your witnesses, getting notice after the grand jury has done its work, and being able to submit an individual cloaked response is enough to remedy, assuming it's beyond criticism, assuming it's higher than mere criticism, to remedy the reputational violation.
And it wasn't enough in 40th, right? Under similar facts or similarly extreme facts as the one in Your Honor's hypothetical, viscerally, terrible crimes alleged there, no indictments, a very lengthy report that where any response would not reasonably be able to be viewed as on the same plane as what the grand jury found there. The court here answered Your Honor's question. No, it's not enough to just have a right to respond or an opportunity to respond, and instead, the identities of those individuals had to be redacted out. And so then it becomes a question of, well, how does that? What happens in situations that are not like that situation, right? And I think what we have here is distinguishable in a lot of ways from that 40th case, in ways that we go into in our brief, but where that total redaction remedy is not is not appropriate as to all the individuals in the report. Although many individuals named in the report are not identifiable in the report version that the judge ordered to be released. Right. So many individuals' identities were cloaked and were given notice and are not here before the court because they were fine with the remedies that Judge Scott ordered.
Counsel, do you believe that the Grand Jury Act is constitutional?
I do, Your Honor.
I've heard from your opposing counsel on that issue, but I'm interested in your office's perception of that.
Of course, Your Honor. So first of all, there's a high standard for facial challenges to statutes, right? You have to come up with an argument that no set of circumstances under the statute, that no set of circumstances would be constitutional under the statute. And here you can imagine, a lot of different circumstances in which grand juries could issue reports that don't even really implicate the right of reputation at all. You can imagine, findings, off the top of my head, findings that, in this case, the grand jury had a 24-month deadline under the statute, and you might imagine the grand jury saying, well, we wish we would have the opportunity to extend it even further and recommend legislative, recommendations to enable the statute to allow you to go further than that. So on its face, there would be other situations as well where the grand jury's reporting function just doesn't even really implicate reputations.
How about this case?
And that would be an as-applied challenge, Your Honor.
Okay.
And so in this case,
do we have an as-applied challenge here?
So I think what we have here, Your Honor, is an as-applied challenge from the petitioner, and then this court's exercise of extraordinary jurisdiction to figure out, which essentially allows this court to take up the case and to ascertain whether other people ought to have been.
Your opponent's arguing for a finding of facial unconstitutionality.
Right, and I think that doesn't make sense.
So can we reach an as-applied unconstitutionality issue?
Well, I think, Your Honor, yes, you could. And what I think we have here is, so it's difficult to understand. All right, I think the supervising judge and the Commonwealth below, we struggled to understand what the legal standard was to apply as to who needed to be notified and who didn't. And I think there are several different avenues this court could take today to set down what that standard would be. And supervising judge in this case and in other cases, I think, should be able to reasonably apply whatever standard this court adopts. We offer one standard. I think the Office of Attorney General applies another standard. Petitioner is saying that anybody who is criticized in a report should be given notice and an opportunity to respond. Any of those standards, I think, would, if applied, if this court were to adopt one of those standards or a different standard, well, then once that's crystallized and made clear what that standard is, I don't think there's any reason to think that.
Can I ask you about that with respect to that standard setting
Right.
proposal? Do you have a view, one way or another, whether we would be improperly rewriting the statute if we vary the in his sole discretion term of the General Assembly's language? Or, in other words, if we say it's, in fact, whether or not we've already gone there, prospectively, if we change that in some way and say, no, it's not in his sole discretion, or that the ordinary processes, including all the way up to King's Bench, of review of a discretionary call by a trial judge is not adequate, and we say, no, we're doing this or that, are we revising legislation in a way we're not permitted to, or what's your view of this issue?
So I think we are not rewriting the statute, Your Honor, if Your Honor were to take that course, for several reasons. So first of all, the legislature is presumed not to enact unconstitutional statutes.
They are, but sometimes they do.
Sometimes they do. But if there's a reasonable construction of the statute that saves it from unconstitutionality, this court can adopt that construction. But in addition to that, the use of the word discretion there is a word that's used frequently in law. Discretion, trial judges use discretion all the time. And when it relates to factual situations, they're given deference. But when they apply the wrong legal standard, this court has de novo review. So once that legal standard is crystallized, this court should presume that supervising judges across the state will faithfully apply that legal standard.
So there's one problem with that, and I'm interested in hearing your response. Let's say we crystallize the standard of when the reputational interest is triggered. Let's say we say it's not just enough for criticism, it has to be stigmatization. And we say that's it, trial court judges, this is the standard. Trial court judge gets the report, trial court judge says, you 3 have been stigmatized, you 4 have not. The stigmatized people get notice and opportunity to heard, the ones don't. Who is going to argue on appeal that the ones that don't were stigmatized, that the trial court judge got it wrong and merely said it was criticism?
Right. Yes, Your Honor. So it could come to this court in a similar posture as it's here now, but that may be a reason to have prophylactic rule that would be over inclusive potentially. But
I don't understand. What do you mean?
Well, so
prophylactic rule that's over inclusive would say everybody named should get notice and opportunity.
I mean that would be at the limit. That would be a rule this court could adopt. And part of the issue, Your Honor, is, and this goes back to Justice Weck's question, I think, before about the City Council, right, is that if Your Honors have a constitutional provision about reputational rights that applies potentially as against all officers of the Commonwealth, and so when Your Honors articulate a legal standard as to when that reputational right attaches, it would have to, at one moment, it would have to be at a high enough level of generality to apply as to various different cases. But then Your Honors may also be able to say, well, in this particular circumstance, like you did in 40th, where where the grand jury finding has certain indicia of have this adjudicatory nature to it that other statements by other government officials don't have, and therefore, in that particular context, there's a need constitutionally to give notice to broader set of individuals than, for example, might be given notice of a city council resolution that says the same thing. We essentially would need to understand, well, what is the right of reputation at the higher level of generality? And I think, Your Honor, Justice Donoghue, you suggested it may, and the AG's office has suggested it may be related to defamation, and that may be one way to conceive of it. But then also to understand, well, how does that get applied under specific factual circumstances, like in a city council resolution, like in a court hearing like this today, or in an investigating grand jury report. And they may have different implementations and constitutionally require different implementations in different situations. Like you can imagine the governor at the State of the Commonwealth speech is still in some sense bound by the constitutional requirement of reputational protection. You can't deprive someone of reputation without due process. But that may have different, because of the context in which that speech is given, you may be less likely to think, when the person says that in that context, it's not as likely to be damaging as it is in the investigating grand jury context. I'm hoping this is not too abstract, Your Honor. But I think that once you get down to the question of, how does that rule get liquidated in the investigating grand jury context? I think that the OIG's proposed legal standard that if a statement,
let's unpack that though. We can set a standard. I think we can. We can define at which point criticism crosses the line to trigger the reputational interest. It's been done at the federal level. We've done it at the state level. That's not the problem. The problem is then what happens? Because unless a person whose interest is being put in harm's way is given the opportunity to litigate the standard, then there's no remedy.
Absolutely. And here's the answer to that question, Your Honor. So Your Honor could adopt more or less concrete standards, right? If it's less concrete, Your Honor is right that there may be some individuals who based on the exercise of discretion, may not be given notice. But if those individuals are given notice, then they have the opportunity not only to give a response at the end of the report, but then to apply for relief in the courts.
But you would agree that and that's a fair answer, but you would agree that, I take it, that that's not his sole discretion. And if you agree, how do we deal with the fact that we're ordering something that is in conflict with what the General Assembly said?
So I think it would be in the supervising judge's sole discretion in the sense of, in the sense that all trial judges, when they exercise discretion, must do so constrained by the bounds of the law, right? And there's case law we cited in our brief about how abuse of discretion doesn't mean the whims of the trial court judge. It means their wise execution of the legal standard as this court eventually will have to ascertain.
An error of law is an abuse of discretion.
It's a much better way to put it, Your Honor. Yes, exactly. And then Your Honor might suggest, well, because of and this is also part of the due process framework, right? If there's a risk of error, you look at the government's interests, the private individual's interests, and then the safeguards and risk of error. To the extent there's a risk of error, right, insofar as the standard might be under-inclusive and therefore people don't get notice and people aren't able to come to this court, then that might be a reason to say, well, okay, in this particular context, when we take the right of reputation, because in different contexts, the right of reputation needs to be operationalized differently. It needs to be operationalized differently in the city council versus here, versus in the investigating grand jury context. And so you say, well, how does it get operationalized in the investigating grand jury context? Ultimately, that's for Your Honors to determine what that standard is going to be. And it may be a reason to say, because of the fact that your reputation may be damaged irrevocably upon the publication of the report, the standard as applied in this particular kind of context needs to extend to this class of people, right? And it may be anybody criticizing the report, it may be anybody about whom a facially defamatory statement is made in the report.
How about anybody mentioned in the report?
I mean, that could be the rule as well. And I think there are countervailing reasons to
But isn't that rewriting the statute?
well, I think that
I'm sort of looking for a line here to save a statute that says in his sole discretion. But,
Right.
I mean,
and that, I think,
you know, we defining what is reputational harm. I just don't. I don't know if I buy the fact that that is different contextually in the broader sense of government action. I don't know if I buy the fact that it's different if it's city council that's doing the defamation versus a grand jury that's doing the defamation. And if I understand your argument correctly, that's what you're suggesting it may be.
well, what I'm suggesting, Your Honor, is if we take the Attorney General's proposed standard, right, that a statement that's facially defamatory would implicate the right of reputation, you can think of context where that can't, context of government speech where that can't really be the rule, right?
They didn't say defamatory, they said critical.
Correct.
And I mean, they said that. So if we were to ask the four of you lawyers, here's a statement about one of you, is it critical? Well, three of you might say no.
Right.
You know, it might say we don't like his tie, but the one who's wearing that, you all have nice ties. But the one who's wearing that tie might think, wow, that's critical. So criticism obviously is in the eye of the beholder. Any one of us is going to be more jealous of protecting our own reputation. So it's easy for any of us to say that's not critical of them, but the person who's named is entitled, isn't he or she, to say, no, that's critical. So don't we have to give due deference to the legislature's use of the term critical, and doesn't that lead us on a slippery slope to say anybody named at least had to have that opportunity?
That's exactly why I don't think that we're rewriting the statute. If Your Honors put meat on the bones of the standard of reputational rights, so the statute, I think, might be unconstitutional if it said the supervising judge, in their sole discretion, can give a right of notice and response to somebody whose reputation is damaged. And if that were understood to mean that the supervising judge could say, yeah, I think this person's reputation is damaged, but based on a whim, I'm not going to give that person notice, that would not be constitutional. But we have here, though, a statutory language that talks about criticism, which is a broader category, I think, than reputation damaging. I think there's no statement that's going to damage someone's reputation that's not in some sense critical. But there are critical statements that are not reputation damaging necessarily. And I think Your Honor's example about a tie, may be a very good example. And this also kind of dovetails with the idea of defamation law. I might be very sensitive about the tie that I'm wearing. I'm not. But if I were, right, you sort of have this kind of eggshell plaintiff kind of situation where you're like, well, that would not be a claim that's cognizable in libel or slander law.
Yeah,
right?
but again, this is all great in the abstract, but that person never gets the opportunity to argue that. And that is one of the reasons why I think several states have said that these investigative grand jury laws, to the extent they name unindicted people, are unconstitutional. Again, even in your situation, you're standing up here sort of presuming the presence of someone in the grand jury process to make these arguments or vindicate these rights, or that there's an opportunity for the eggshell defendant to even be an eggshell defendant.
Right.
That doesn't exist.
Well, I think it doesn't in the following sense, Your Honor. The supervising judge, I think, This is not just the Commonwealth unilaterally saying who should or shouldn't get notice. You have an independent supervising judge who's going to be there, and will need to apply the legal standard.
I'm going to criticize you for that.
Well, fair enough. Fair enough. But Your Honor, so then, and again, it's hard to talk about in the abstract, but if we talk about a specific legal standard that could potentially be adopted, like the OIG's legal standard about, whether a statement is facially defamatory, or even, potentially facially defamatory.
Well, can you just stick with your again, the procedure? You said you were suggesting and going on the path of the trial judge being the safeguard for the eggshell plaintiff.
Well, so we have.
Is that true?
Yes, in the following sense. So the trial judge. So you could have more concrete and less concrete standards, right? If Your Honors adopt a more concrete standard that the trial judge could look at and say, here's the legal standard. Here is what's said about the person in the report, and if the statements in the report implicate the legal standard potentially, then they would need to be invited in front of the court, given notice, opportunity.
Who advocates to the trial court judge? Yeah. Yes, this triggers it, or no, this doesn't. It's a one-sided advocacy at that point.
Part of the issue about that, Your Honor, is fundamental to the nature of grand jury processes.
Oh, I agree with you. Yeah.
And it's not. There's no way around it, right? It's because the grand jury process needs to operate in secret, and there needs to be.
Well, there is a way around it because other states who have looked at this issue have stricken. They've either struck down investigative grand juries, period, or they have limited the ability of grand jury reports to include the identification of unindicted people.
So
that's how those states have addressed it.
Right. Well, so when you, that would be this court shouldn't adopt that rule because there are less restrictive alternative rules that would still.
I think we're all trying to figure out what that would look like.
Right. So yeah,
we're all trying to figure that out.
So it would be a rule that would ultimately give notice to individuals whose reputations might be put at issue, and candidate rules for that. I mean, the rule that we advocate for in our brief is one that we think made the most sense out of In re 40th, but it is not.
The rule gets you halfway. The rule gets you halfway. I'm not talking about the rule. I'm talking about the process for the advocacy of the rule.
And then in that sense, then supervising judges need to be presumed to operate in good faith and under regularity, and regularly apply this court's legal standards. And if that presumption weren't available, there are a whole lot of other ways that a rogue supervising judge could damage someone's reputation.
It's not about a rogue. It's not about rogue. It's about what if the judge gets it wrong? So, not because they went rogue, but because they didn't have the benefit of advocacy.
And so then so the risk of error is part of that due process analysis, and then you need to understand the Commonwealth's the weight of the Commonwealth's interest, the weight of the private interest, and then the risk of error. And I would submit, Your Honor, that this is actually a paradigmatic case for why there's actually a really important Commonwealth interest in the preservation of these reports. To the extent there's a risk of error, there are still compelling interests in having this outlet available.
Mr. Margolski, I think we truly understand your arguments. Unless the justices have any other questions, I'd like you to wrap up, and we'll hear from Mr. Eisenberg.
Sure. No, I appreciate the opportunity to speak to Your Honors. Thank you so much.
Thank you.
That was a very good wrap-up.
Good argument. Thank you.
Mr. Eisenberg.
May it please the Court, Ronald Eisenberg for the Office of Attorney General. Let me discuss the kind of process that we think is necessary in order to effectuate the legislature's desire for grand jury reports. It is that we draft a report, that we share the relevant portions of that report with anyone who might conceivably be criticized within it, that we allow that person the opportunity to testify, to appear before the grand jury, that we allow that
Does
person...
that person appear with counsel who has the ability to direct examination?
No, Your Honor. They would appear in the same way as other grand jury witnesses. Of course, there are differences between the grand jury process and the trial process, but I would like to sketch out what that process we think should be. That they have the opportunity to go before the judge and make arguments about any findings against them that are in the report, whether they meet the proper standard, that they have that kind of opportunity for that kind of hearing before the
To make arguments or to testify under oath?
They get to testify. These are additional things. They have the right to testify. They have the opportunity separately from that opportunity to argue to the judge that findings stated against them in the report are not supported by the evidence. And they have the opportunity, as the statute guarantees them, in addition to those other things, to attach a public response to the report if they wish to do so.
Mr. Eisenberg, are they subject to cross-examination by the
No, you are
Commonwealth?
not, Your Honor. The process here will be different than it is at a trial because the consequences are different than a trial.
Thank you. I'm just trying to establish your procedure.
I understand, Your Honor.
Can I
that-
follow up with one question? The petitioner in this case got all of the procedural protections that you just mentioned, correct?
I think that he got at least in substance those protections. And we should keep in mind because
others that you mentioned in
Correct.
your brief.
yes, there were others that did not. And let me get to the rewrite question because I think that relates closely to the procedures that I've just mapped out. It's a question that came up during argument in the diocese case. I remember it well, and I believe that the court answered that question and specifically said in its opinion that the investigating, this is a quote, the Investigating Grand Jury Act does not restrain the attorney for the Commonwealth from implementing additional procedural protections, unquote. Now, if the statute does not restrain me from implementing additional protections, it surely does not restrain you from implementing additional protections. And let me say that you do that all the time. There are...
do that without, I'm not saying you're wrong, I'm just asking how we do that without rewriting the term sole discretion.
Sole discretion, Your Honor, doesn't mean sole the judge as opposed to this court. It means sole the judge as opposed to the Commonwealth or some other party. Of course, this court still has that reviewing authority. And of course, this court gets to decide what an abusive discretion would be as it does in every other case. Even if, and this is certainly not necessary, I think, Your Honor, but even if the problem were the word discretion, then the answer would be to strike that word discretion, not the statute as a whole.
We're locked into, under that view, and I'm not saying you're wrong, I'm just asking, under that view, we would be locked into granting King's Bench essentially in any investigating grand jury report issuance to the extent that there's anybody who feels he or she has been criticized in the report.
Your Honor, if you want to change the procedure to review of those kinds of decisions by a supervising judge, you are certainly entitled to do that as well. The court does that all the time. But what this court has said is that for a facial challenge to the constitutionality of a statute, there must be no circumstances under which the statute can be made to work constitutionally. The court said that in Pownell, Justice Doherty, and again just 2 weeks ago in Barris, and those are statements of the court that are binding on the court, and the way in which the court can do that here, and the way in which the court often does that, is through the promulgation of rules of procedure. We have whole chapters of the rules of procedure that implement statutes that on their face don't provide those procedures and would certainly, I think, be unconstitutional as applied without any kind of proper procedure. Chapter 7 is the sentencing procedures which implement the sentencing code. And without it, without proper procedures, it wouldn't be, you couldn't constitutionally impose those sentences. Chapter 8 is all about the implementation of one specific statute, Section 9711, the capital sentencing statute. Chapter 9 is the PCRA section of the Rules of Criminal Procedure, and it implements the PCRA, the Post-Conviction Review Relief Act. It's an act. It's a statute. All of these procedures supplement statutes in order to allow them to operate in a constitutional fashion. And that's all that we are asking for here, and it's what I believe the Court itself called for in the very first diocese case. And we have been trying to do that ever since. The Court said, the way you're doing things is wrong, it's not enough, do more. So we've been doing more, and it's, even though many years now, still early in the process in the sense that there just aren't that many grand jury reports that come up. And of those that do get released by a grand jury, this Court doesn't necessarily see them all. We have actually had grand juries release grand jury reports that you didn't get petitions about. And we'd like to think it was because we went through these procedures to eliminate those problems. Now, I can't guarantee you we're always going to be able to do that. You will never have a case.
Those are really secret grand jury reports. We don't even see
Well, they're public, though, because they have been released, because they were not challenged before release, in part at least.
I understand.
Because we went through the proper steps to guard these problems. Now, is that going to be a different process than we have at a trial? Of course it is, because different outcomes require different kinds of procedure, different kinds of due process. And a procedure that results in your going to prison is not the same procedure that we apply for the deprivation of property. And a procedure that we apply for the deprivation of property is not the same procedure that we apply for the deprivation of life. So, too, with reputation.
You're saying the right to reputation is a lesser?
No,
right?
I'm saying it's a different right. The Court has said that the right of reputation is at the same level as the right to property, life, and liberty. And yet there are clearly differences between property, life, and liberty, Your Honor, and the processes that attend to them are different. And the same is true with reputation.
But the right, I can probably agree with you that the processes will be different, but they still have to end in the same place, where the process results in the right being vindicated or rejected.
That's correct, Your Honor, and that's why you have put a great deal of emphasis on notice up front, because that's the beginning of the process, and I agree with you. And if the Court believes that that means there has to be notice in every case where somebody is named, then the Court can write a rule to that effect. But keep in mind, Your Honor, that even not naming people in a grand jury report or any other kind of government report is not necessarily enough to prevent them from having a reputational claim. It is impossible to discuss certain kinds of misconduct or societal problems without implicating somebody because they may be at the top of the food chain. They're an important person. And if you talk about their organization, there may be no way to do that without shedding some light on themselves.
Well, you can do that without including their official title.
And this report, Your Honor, has been redacted. The report that's before this Court has redacted the name and title and similar identifying information of the petitioner. It's already gone. It's out. Now, the petitioner has claimed that there will be numerous people who will know just from the subject of the report who the report is talking about. And I agree that sometimes that is the case. And to say that that is unconstitutional is to say that there is no right for any kind of government reporting process to identify that sort of misconduct. Not city council, not grand jury, not the inspector general or the auditor general.
So we're clear, the government doesn't have constitutional rights.
The people have the constitutional right, I think, to hear from the government.
No, they don't. People have the constitutional right to not have their rights infringed by the government. There's no constitutional right for the government to issue a grand jury investigative report and identify corruption.
If the Court wishes to make it impossible for any governmental agency to issue this sort of report, then the Court can vote to do so. I think it would be a mistake, and I think that, in fact, our cases and the Constitution itself, as we have outlined in our brief, have always recognized that there is a balance between the right to reputation and the need for public debate. Not just private speech on public debate, but public speech by government actors on issues of importance to the public. And there is no way, I would respectfully suggest, to say that a grand jury cannot do that, but some other governmental agency can.
Except the grand jury doesn't happen in a public debate.
Oh, the report is the report.
No, but the debate happened in front of the grand jury, and it wasn't much of a debate. It was a one-sided.
That's protection, Your Honor. The grand jury secrecy protects anybody involved until
Mr. Eisenberg, I'm not quibbling with the how I know how grand juries are structured. I'm not quibbling with that. I'm responding to your points about public debate. A grand jury is not a public debate.
My response is that the beginning of the public debate that I'm referring to, Your Honor, is not the beginning of the grand jury process. It's the release of the report. That's where the public debate begins when we're talking about a grand jury report. And the difference between grand juries and other governmental functions that might make findings, that might make statements that would be at least implicitly criticism of somebody, whether named or not, the difference is that we've got a lot more procedures when it comes to grand jury reports. If the governor or the district attorney, in your example, wants to stand up and say, I've done an internal investigation and here's my findings, there's no procedures that exist currently for how that's going to happen. And they can say whatever they want. In the grand jury process, we have a supervising judge. We have a court system. We have the kind of procedures that I've laid out. We have the right of response. We have numerous protections that do not exist for any other kind of governmental action of this sort. And yet, if the grand jury process resulting in a report after all those procedures is still unconstitutional because it violates the right of reputation, then so do any of those other kinds of government reports, Your Honor.
Mr. Eisenberg, I know I haven't given you as long as your colleague had, but I think we fully understand your argument. I'd like to give the justices an opportunity if you have further questions.
Yeah, I have a question. The Petitioners' Council, on behalf of others who are not before us, has argued that this is a facially unconstitutional statute. Counsel for the district attorney pointed out correctly, I believe, that if there's any way that the statute could work in a constitutional fashion, then it's not facially unconstitutional. So, what do you suggest we do with the constitutionality challenge that's before us?
I think that you have to reject the facial challenge that's before you, because there are circumstances under which the statute could be constitutionally applied.
Okay, and so to the extent that we decide that we really for a long time overlooked the fact that there should be rules for the grand jury coming from the court, as we do in every other instance possible. We do that as part of the function of what? Correcting due process issues apparent in this case? Or what are we doing?
I think that you do that as you engage in your rulemaking process in all areas, Your Honor. Events happen in cases in life that suggest the need for response, and the rules are often the response to those actions.
Let me be more particular. Your office points out 7 individuals who, in your office's judgment, should have gotten due process notice and maybe something else. Are you suggesting that there were, in fact, due process violations that require action by our court vis-a-vis those individuals and this report?
I think that if the court believes that the references to those individuals meet whatever standard the court sets for reputational harm, then the remedy would be to remand to provide notice to those people and to give them the opportunity to do the things that I've outlined and which the lead petitioner has had the opportunity.
Is there an action grand jury? Is there a grand jury to remand to?
It would be a remand to a supervising judge, Your Honor. And of course, as in the diocese case, because the grand jury term has expired, the only way to deal with any problems that might be identified would be through redirection. I neglected to point out an important point about the processes that I outlined, Your Honors, which is that we attempt to do them within the time constraints that we have, and the time constraints are the term of the grand jury, which is statutory and which the Court has already said that it would not be able to rewrite the statutory term, and I understand and accept that. We then try to work, we know that the clock is ticking when we do these, and it's not always easy for us to get all those procedures done within the year and a half to 2 years that we have in front of a grand jury.
Not always easy for us either.
Mr. Eisenberg, what is the position of the Office of the Attorney General with regard to this particular report?
That, as we stated in our brief, the general findings of the report are supported by the preponderance of the evidence, that the process provided to the petitioner satisfies constitutional requirements, and that therefore, while further actions might be necessary as to some of the named individuals, the report overall is an appropriate one. And
So are you saying we should redact the names of those 9 or 12 individuals
the
that were
supervising
not?
judge should do that after deciding whether they meet the standard for reputational harm and giving them the opportunity to respond. We have certainly had situations where people have given notice and elected not to respond, not just not to file a written response to be appended to the court.
That happened in this case, did it not? It happened
Yes,
with one of the individuals.
that is
in this
correct,
case.
Your Honor. There were some people who were given notice and chose not to contest anything that was in the statute or to ask to test.
But there were also, what, 9 that were not given notice? 9 or 12, I don't remember.
I think we have identified 7 or 8 or 9. They were, and they're listed in our briefs, and they're identified. They were relatively minor characters, but I don't see that as being enough to say that they don't have an interest here.
Justice Brobson?
Mr. Eisenberg, I want to give you the same question that I asked the district attorney's office, and you've laid out your process. We set the standard. The trial court judge says, okay, there's 7 people. The criticism of 4 of them reached the standard. I'm going to give notice to the 4. The 3 don't reach the standard. I'm not giving them notice. How do the unnoticed people know that that determination was made such that they can challenge it on appeal?
They don't, Your Honor, and if the judge didn't err, then it doesn't matter. And if the judge did err, then he erred, which can happen regardless of any process that the court might adopt. If the court adopts a rule that says you have to give notice to everyone, every single person who's named, and the judge doesn't do that, then you have the same problem. But it doesn't mean that the process is wrong or that the Grand Jury Act can be thrown out. You mentioned the Loudermill case, Your Honor, which was a discharge case, and the court said, quote, some kind of hearing is required. And a judge could err. A judge could fail to give notice, or the government entity could fail to give notice. Now, they were clearly entitled to notice and to some kind of hearing. If they didn't get it, there was a harm, and they may have an action. But it doesn't mean that you can't have a discharge process because sometimes a judge or a government entity might err. So that's the response.
All right, this was well argued. Anything else, Mr. Eisenberg?
One small point, and I know it's very late, Your Honor, but this is a point that I don't think has been addressed and I think should be, and that is the statutory definition of a report and whether this case meets it. There's a point that I think has been overlooked, which is that the definition does refer to public corruption, but here's what it actually says. A report submitted by the investigating grand jury to the supervising judge regarding conditions relating to organized crime or public corruption or both, semicolon, or proposing recommendations for legislative, executive, administrative action. The recommendations clause of the definition does not depend on public corruption or organized crime. That language, I think, was especially intended for things like the Crime Commission that used to exist, but the legislative definition is not limited to does not limit reports to being those that are about organized crime or public
Mr. Eisenberg, that coordinating conjunction means that there's what? Equivalent synthetic meanings? The question I have is the 2 recommendations in this report. Tell me, Was that an internal recommendation to improve the DA's offices, working with the police department, or where was that directed? Because of the coordinated conjunction, the recommendation must be to the legislative, legislative, executive, or administrative. Doesn't say internal. My understanding of the recommendations is how the DA's office needs to process this better with the police officers by sending a DA out with the cop.
I don't see it that way, Your Honor, and I'm looking at page 102 of the redacted report, which I'm not going to refer to any improper information here. There are several recommendations that the investigator should document, the police investigator, it's not about the DA's office, should document the reasons for that declination, that the department should track the declinations, that it should keep statistics about reports of use of force, and that those statistics should be made public, and that those statistics should be made public.
With all due respect, they already exist. This is just saying, other than the documentation, which exists, they're just elaborating or expanding on the declination purposes. We did that. We know that. We did that in charging all the time when we were prosecutors and the police sent over their paperwork. We declined it and sent. That's an internal process. That's not a recommendation, unless the office has changed since I sat there.
These are recommendations about how the police department should conduct investigations, which seems appropriate in an investigation of how the police department conducted an investigation. And they go further to say there should be audit by an outside agency, which would be either something that the police department would have to volunteer to do.
We have the Police Advisory Council already existing in the city of Philadelphia. Don't we not have?
I don't know whether that it reviews the kind of information that's discussed here. So the fact that one could differ about the importance of the recommendations, I don't think is enough to say that this report doesn't meet the definition in the statute.
Fair enough.
Isn't this, I'm sorry.
No, go ahead, Justice Lemon.
Isn't this report in content and kind so different from the report with regard to the Catholic priests? Because this is a single instance of a single event, whereas the previous report was many, many, many instances of inappropriate conduct over a wide span of years.
Criminal conduct, just lost by the statute of limitations.
Not every grand jury report is going to have the scope of the diocese investigations, Your Honor, which weren't just statewide. They were nationwide and worldwide. But there, I believe, have been many reports that arise from a particular incident. And what the grand jury believed here was that what they were seeing and what they were told were common practices were the course of the concern. So in other words, the grand jury didn't think that the evidence showed that people made a one-off mistake that they were never going to make again. The grand jury thought that the evidence showed that there were common practices that were exemplified by this case, but not present only in this case.
Don't you find this case more in line with In Re Grand Jury number 18 or 19, the Boy Scout issue?
I believe I remember the case, Your Honor, from Franklin County, and I don't, having been here for that one as well. I think it is very different because that case was about the actions of a single individual whose offenses were time-barred, and there were really no recommendations that dealt with anything beyond that case and beyond that particular person. There were no suggestions about how to handle similar circumstances in the future at all. And that's very different than this case.
Thank you. Mr. Eisenberg, we understand these were great arguments by all three of you, and we appreciate your time. We're going to take just a short minute for Mr. Minner to get things set up for the second argument.